Good morning, Your Honors. The matter before the court this morning is the case entitled Ballinallee Properties, LLC et al. Versus Sean Mateo, case number 25 AP 096. Appellant Sean Mateo is self-represented. Representing the appellee, Ballinallee Properties, LLC et al., is attorney Jeffrey P. Gavin.
Thank you very much. Good morning again, Mr. Mateo. Can you hear me, sir?
Good morning, Your Honor. Yes, I can.
All right, and we can hear you. You understand you have 5 minutes, and we'll give you an alert when you have a little bit of time remaining. So please go ahead.
Okay, Your Honor. There's so many things wrong with this case. So many inconsistencies. I'm going to focus on one being in general. A judge cannot open up a resolved case and amend it after it's already been amended to add a new address, add more peoples to an eviction that was never even heard in court. This is a violation of due process. It's against constitutional rights. We have the right to, be heard in court. And 2323 and 2325 are two different properties that I was paying Mr. Gray for. I handed him money on both separate properties at separate times, and that was calculated by receipts as that. Now, when it went to court, only 2325 went to court. 2323 was never mentioned. My fiance, Brianna Lown, was never mentioned in the court. Now, after the court, the lower court judge, Judge David Barra, repeatedly violated my constitutional rights and siding with Ballinallee Properties, which doesn't exist. That property, that Mr. Ballinallee's Properties hasn't been for several time now. It doesn't even exist. So somebody who's suing me doesn't even exist. Patrick Gray exists. So I acknowledge only Patrick Gray, not Ballinallee Properties. So once an eviction case is resolved, judgment entered, it cannot generally be reopened to relitigate or expand the scope of new unrelated issues or parties. I lost somebody. Can you guys still hear me?
Yep.
Yes.
You're
Okay.
fine. Yep.
So basically, it's a violation of due process. What the judge did in the lower courts was open up a resolved case, and added a whole nother property and two other peoples to be evicted from said property without going to court. So it's a violation of due process for two people times two. It just can't be done. The whole case must be voided. The court has to recognize that. There's other issues. I mean, I was never even served properly to begin with. The court had no jurisdiction to ever hear it to begin with since the beginning. He served me 3 years prior and then decided to take me to court 3 years after serving me the eviction. That's not, you can't do that. You have 60 days, and that was not done. So the court should have never even heard the case to begin with. I've sued this judge for violating my constitutional rights several times. They threw it out. He violated due process. He violated, my rights. I put motions in for him to recluse himself. He refused to. Pretty much, I'm going to focus on the fact of the matter is the judge cannot amend a resolved case and add new properties. It's just a violation of due process. So I'd ask the court to see that and, void the whole entire case and let it go to resue ourselves in the lower courts and go from there. And I'll pause my time so I can have extra.
Okay. Well, yeah, you're reserving your time. That's fine. And so we'll turn to counsel for the appellee. Please start by introducing yourself and your client and then proceed.
Good morning, Mr. Chief Justice. May it please the court. This is Jeffrey Gavin for the appellees, Patrick Gray and Ballinallee Properties, LLC. This argument will briefly address the points raised by Mr. Mateo. This morning, we heard a new objection, that is to jurisdiction, which was not raised below. However, believe that objection was waived by Mr. Mateo proceeding all the way through trial and judgment. Having briefly addressed that issue, Judge Barra was qualified. The appellant, Mr. Mateo, waived his right to a jury trial. The trial court appropriately exercised its discretion on the admission of evidence and in assessing its weight and credibility. The trial court had the requisite authority to amend the judgment as it did, and Mr. Mateo's right to due process was respected. Judge Barra was qualified. Mr. Mateo did not meet his burden to show disqualification for interest under 12 VSA Section 61, and he failed to meet the requirements of Civil Rule 40, both in form, lacking an affidavit, and in substance, without any clear, affirmative, or reasonable showing of bias. Second, Mr. Mateo waived his right to a jury trial. The Seventh Amendment right under the U.S. Constitution does not apply to the states, but the Vermont Constitution guarantees the right. Mr. Mateo failed to timely file and serve his jury trial demand according to the rules of civil procedure. Despite this, the court could have granted a jury trial. With that said, it did not abuse its discretion by refusing to do so. Third, the trial court appropriately exercised its discretion as to the admission, weight, and credibility of the evidence. At the outset of trial, the court encouraged Mr. Mateo to focus on the most important evidence. It allowed him multiple substantial opportunities to proffer documents, a meaningful amount of time to testify, and the opportunity to call witnesses. The court did not err in excluding the proffered evidence, which was almost entirely hearsay and often confusing, cumulative, and irrelevant. Nor must the court be held responsible for Mr. Mateo's failure to meet the burden of proof. The trial court had the authority to amend the judgment. Mr. Gray sought possession of property. Credible evidence in the record supports the finding that the property had 2 E911 addresses and that Mr. Gray sought possession of the entire parcel regardless of the subdivision. The court rightly found that the entire parcel was at issue and awarded substantive relief based on that finding, specifying that its order of possession applied to both addresses and required removal of all occupants did not change the substance of the original judgment, which awarded possession of the parcel to the plaintiffs. Finally, Mr. Mateo's right to due process was respected. Mr. Mateo was adequately notified of his rights and obligations under the rules of civil procedure and evidence. He was given a fair and meaningful opportunity to present his defenses, objections, arguments, and evidence. Whatever he might say about Judge Barra, Mr. Mateo did not present any actual evidence that the judge was not a neutral decision maker, and he was heard on this point by 2 other Superior Court judges. Finally, the fact that we are standing before this court today is yet further proof that the Vermont judiciary takes seriously the right to due process, and I have faith that the court will make clear.
You have 1 minute. You have 1 minute, counsel.
Thank you, Your Honor. I have faith that the court will make clear that it holds that right in due regard. Again, in summary, Judge Barra was qualified. Mr. Mateo waived his right to a jury trial. The trial court appropriately exercised its discretion with regard to the evidence and conduct of trial. The trial court had the authority to amend the judgment, and Mr. Mateo's right to due process was respected. The judgment below should be affirmed.
Okay, thank you very much. How much time does the appellant have, please?
Appellant has 1 minute and 22 seconds remaining.
Mr. Mateo,
Yes, Your Honor.
please go ahead.
Okay. So Mr. Gray subdivided the properties with me. In the beginning, I paid him separately on both properties. When he took me to court for one property, 2325. 2323, Route 7 was never mentioned in this eviction case, nor was my fiance, Brianna Lown. Okay, that's 2 different properties. A judge cannot amend a resolved case and violate my due process I have the right to go to court on 2323, and so does Brianna Lown. Okay? You cannot amend a resolved case and add a whole nother address to be evicted on without going to court. It's just, that's absurd. For them to even counterclaim that you can do that is absurd, Your Honor. I'm not a lawyer, but I mean, I've done a lot of studying, and you just can't do it. It's a violation of due process. I did not waive any rights from the beginning. I put motions in for a jury trial. I was refused every single time, Your Honor. You know, my rights were very violated. Again, the judge had no jurisdiction to even hear this case to begin with because
You
Mr.
have
Gray.
1 minute, Mr. Mateo. You've got 1 minute.
Okay, Mr. Gray had never even took me to court the right way. He had 60 days to have me served and go file a court date. He did it a years upon. So this court, the lower court, had no right to even hear this case. They did not give me enough time to evidence. They did not do a jury trial case. And if you do any kind of FOIA request, this judge, David Barra, Mr. Gray, is a professional con artist. He's been sued several times. And every time that this judge has heard his case, he's sided in his favor.
Okay.
There's something there.
All right. Thank you very much. Your time has expired. Please call the conclusion of the hearing.